Hi, everyone, and welcome back to Navigating Estate Planning with Caress Law. I am Tammi Caress, and today's episode is one I think every family needs to hear. We are talking today about delay, and delay specifically the cost of waiting too long to take action after a loved one passes away. And now it's time for the disclaimer. The information contained in this podcast and associated material is intended to furnish listeners and users with general information on matters that they may find to be of interest. The information in this podcast provided by Caress Law and its agents are for general guidance and is not intended to replace or serve as a substitute for any advisory, tax, estate planning, or other professional or legal advice, consultation, or service. Sometimes we may reference third-party materials or websites. Such links or references are only for the convenience of the listener, user, or browser. Caress Law and its agents do not recommend or endorse the content of third-party information or sites. You should consult with appropriate Caress Law professionals or other professional advisors for advice concerning specific tax, estate planning, or other matters before making any decision. In summary, this is not legal advice. It is general information, and if you need legal advice, please seek the counsel of an attorney. Thanks so much. Now, let me say this up front. It is completely normal to feel overwhelmed after losing a loved one. Grief is hard, life is busy, and you just may not know where to begin. And you may not know who's supposed to be in charge. But the truth is, delaying estate administration, whether we're dealing with a trust or a will or neither, can be one of the most expensive decisions a family unknowingly makes. So today, I want to walk you through the costs of delay and how to avoid them. But first, I want to talk about why this happens. Most people don't delay out of neglect or irresponsibility. They delay because they're grieving, or they're overwhelmed, or probably both. They don't want to go into this legal mode while still processing the loss. Sometimes there's family tension, or sometimes we say, let's just wait until after this holiday or whatnot. But then suddenly time flies by and it's now 6 months later and nothing really has been done. I've had clients tell me I just wasn't ready, and I completely get that and understand. Unfortunately, there are things the legal and financial system doesn't wait on. Deadlines start ticking, documents will go stale, and those delays just continue to compound issues as a result of the delays. So today we're just going to walk through what some of those issues are, and hopefully this will help you understand why we shouldn't delay. It also may help you understand when you are actually going through your own estate plan and determining who is the person you're going to put in charge of settling your own estate. Some of these issues may help you recognize or realize the person you thought should be in charge maybe won't be the right person, not because they can't do it, but because they may take a long time to do what's needed. So let's get started. The number one driver of increased costs, in my opinion, of delaying is missed tax deadlines. Now, just because someone passes doesn't mean we get to avoid those taxes. We certainly don't. And there's also taxes that are assessed as a result of someone's death. And those deadlines are associated with the delay. So essentially, I'm talking about the estate tax return deadline. That's one of the taxes. The estate tax return, I have lots of podcasts and episodes that touch on this subject. But just to give you a quick refresher, it is a tax that is assessed on estates after a person dies, and it's because the value of their assets are above a certain threshold. So for Oregon, that threshold is $1 million. Washington, starting July 1st, 2025, that threshold is $3 million. And then this year in 2025, the federal threshold is just under $14 million. Many people aren't subject to the federal estate tax deadlines. However, the federal estate tax amount is set to change in 2026 and actually be cut in half of that 14 million. It's actually 5 million adjusted for inflation, which we won't know until the end of this year or beginning of next year what that is, but it's likely going to go down to $6 or $7 million a person. However, the current administration in charge might change that before year end. So we'll wait and see on that one. But my point is, when it comes to estate taxes, it is a moving target. It changes as the years pass. So it's good to keep an eye on that. But in terms of getting that tax done, depending on your jurisdiction, it typically is within 9 months of a person's passing. In Oregon, it is 1 year. So Oregon allows a little bit longer timeline. And there are certain things that need to happen in order to make that deadline. And one is collecting the assets and valuing those assets as of the date of a person's passing. And that does take time. If you have someone that you've put in charge of the estate who's with it, they can, if they have the time, get to valuing those assets within the first couple months of death. But if you have complicated estates, it could take a little longer. Or if you have unique assets, it could take a little longer. So the sooner the person in charge, we're going to call them the fiduciary, which would be like a successor trustee or an executor of a will, the sooner they get started, the better it is for the estate, because we do have that deadline of 9 months to a year. Now, yes, there are extensions that can be done, but just like any other tax, penalties and interest will occur after the deadline passes. So it's good to get things going, because if we miss those deadlines, we are going to have IRS penalties, state penalties, interest, and we might possibly lose some deductions that could be available. So missed tax deadlines is super important. Unfortunately, governments don't care that someone's passed, and they actually tax because someone passed. So that's one of the big ones here that we'll talk about today. The other is less obvious, in my opinion, and it is frozen assets. Now, a lot of people know, because they've experienced it, when a person dies, a lot of their assets are frozen until the executor is appointed through the courts to settle the estate when we're dealing with wills. The trust assets, when we're dealing with revocable trust and the trust creator died, those trust assets can also be frozen, because when a person has a revocable trust and they die, that revocable trust turns irrevocable at the moment of their death, which means it becomes a separate tax entity, which means we have to get a new tax ID number. We have to get paperwork in place so that the successor trustee can step in and start accessing those trust accounts and so forth. And during that time, the assets are frozen. And so there can be some missed investment opportunities. I had an estate, a fairly recent estate, where there were delays in getting the person in charge through the probate courts. And essentially, this probate account, which was the primary account for the estate and had most of the wealth inside that account, we couldn't do anything. And this is at a time when the new president was going into office and the market was extremely volatile. And there are repercussions because that account is frozen and we can't make any decisions. We can't do any actions. And it could greatly reduce the value of that asset as a result of the inability to act. So if we hadn't delayed, or the personal representative hadn't delayed, he would have been in a better position. The other item to think about is real estate. The longer it sits there, it could go into being uninsured because, there's no assets, no one's been appointed to step in. And so the insurance lapses on the house, it doesn't get paid. And now you're exposing this property to risks because it's uninsured. You're also allowing the property to sit vacant for a longer period of time, and it can just start degrading. So unmanaged assets can start losing its value. So there's a lot of loss of income that can occur. We can be forced to sell property in a down market because someone delayed. Property can be damaged, devaluing that property. And then, of course, I talked about insurance. We can have increased insurance premiums when we finally do get someone appointed because of the issues of it being uninsured or policies not being paid in the past. Those are some of the things that can happen when we delay getting started. The other cost driver, if you will, of delay is legal and administrative fees increase over time. That's because the longer an estate is open, the more items that are required or reporting requirements, and the more things that need to be done on an annual basis. So attorneys can charge more when we go into more of an urgent or a reactive situation, or if we have to go back and fix past mistakes, always costs more to do those fixes because of delays, where we wouldn't be in this position if there wasn't delays. There are oftentimes more hours needed to administer and settle the estate when things are left disorganized. Also, the longer we keep an estate open, the more, if we're in court, the more filings that we have to do. We have to do an accounting to the court every year. We have to do extensions because a client maybe didn't get us the information we needed by the court deadline. I actually have unfortunately dealt with this way too often in my career. An example is we have a probate, and the probate court requires an inventory is filed within 90 days. And we have to get a grasp on the assets and their values within that first 90 days in order to make that court deadline to file the inventory. If we don't make that court deadline, guess what? Me, as the attorney, I have to file an extension with the court, and that takes time, and time equals money in this world. And it takes more time to do that because it's paperwork that we have to do because the person we're working with didn't get us the information that was needed. And that just increased costs to the estate. Another example when we're dealing with trusts is trusts actually have to do a report to all the beneficiaries annually and upon a termination of the trust. So if we have delays and we don't get the information we needed to do that report, that can cause some mistrust, if you will, with the beneficiaries. But then also, now we have to do the report. And if things didn't get done before the next reporting year, we have to do another report, and that just takes more time. So legal and administration fees will increase the longer the estate is open. I should also mention when I talked before about a revocable trust becoming irrevocable, and when I mentioned before about a revocable trust becoming irrevocable and that there is it's now a separate tax entity, well, that trust now has to file income tax returns during the administration. And if the estate is being delayed in settlement, we're going to have to file multiple tax returns for each tax year that trust or estate is open. And that also increases costs because we have to hire CPAs. And when we have to file tax returns and there is a tax due from the estate or trust, it's actually trust and estates are taxed in a higher tax bracket than individuals. So those legal administration fees can really increase over time because of delay. Just more work you have to do, the longer an estate is open. Kind of mentioned this before, but I'm going to touch on it a little more. The longer a person delays in administering or settling an estate, it only can breed mistrust among the family. Because if things aren't happening, they get concerned. And you are only increasing the opportunity or the ability for family members to become disgruntled, causing some infighting, which I know most of my deceased clients, that was their main goal, is they want to keep the family intact when they're gone and make things as easy as possible. But if we are delaying those beneficiaries that are lying in wait, they get concerned and they may even petition the court to have someone removed. They might start having demands for accountings, and it can even just go into litigation because things are taking too long. I have dealt with estates where we have had a heart-to-heart conversation with the person we're working with because there's an operating business or there's rental properties that we need to manage. And we've had agreements where beneficiaries say, we just want to sell the properties and be done with it. They don't want to deal with the real estate after. And we have to talk to our client and say, you have to act on this quickly. You can't just sit and lie in wait because it's only going to breed mistrust. And we're worried that there could be litigation. So my job is to protect that trustee and personal representative and make sure they're doing what they're supposed to be doing. But delay is going to make their lives and their job very hard. And it's also just going to increase costs. I mean, I will have beneficiaries call my office for updates. And the more and more they call, every time they talk to us and we're giving them an update, it is fees that are assessed against the estate. So delay can really increase the chances of family conflict. It can increase the chances of litigation. And trust me, we do not want estates to go into litigation. All litigation benefits are attorneys because they're the ones who have to litigate and they have to get paid for their services and their time, but it comes out of the estate and it's just taking money away from the beneficiaries. So family conflict and litigation risk is real when we delay. I want to also talk about creditor claims. The longer an estate is open, they are more exposed to risk of unexpected creditor claims or lawsuits. So most jurisdictions in Oregon and Washington are both in these type of jurisdictions. They have the ability to, they either require or they have as an option for the fiduciary to go through a creditor process. So in the Oregon probate courts, it's required. Otherwise, as trustee, it is not required. And in Washington probates, if the executor has non-intervention powers, the creditor process is not required. However, I often recommend we go through it, even if it's not required, because it is a way to cut off future unexpected creditor claims or lawsuits. Essentially, we go through this process. We have like a 4-month window where we're giving known creditors actual notice. And we also have the ability for unknown creditors to make claims against the estate. When an unknown creditor makes a claim, of course, we're going to look and see is this valid or not. We might file a response back that says we're denying this claim, it's invalid. But my point is that 4-month window, once that 4-month window passes, doesn't necessarily mean we don't pay those creditors who make a claim after that 4-month window. Because if creditors can make a claim after that 4-month window and it is a valid claim, the estate is obligated to pay that claim. However, if the estate is closed, if we went through the creditor process, then the estate closes and then an unexpected or unknown creditor comes out and tries to make a claim, guess what? They're barred from making a claim. And the estate doesn't have to worry about that. I can tell you, I have dealt with a probate where I had a personal representative who just delayed. They were slow to respond, slow to get information that was needed, slow to take action on things we said they needed to do. And the estate could have been closed so much sooner, but we had an executor who just wasn't moving. They just weren't doing what they're supposed to do. Well, guess what? We had it was a $20,000 creditor come out that no one knew about. The executor didn't know about. They came out of the woodwork. This was in year 2 of the probate. Creditor period had lapsed. And guess what? The executor had to pay that creditor because it turned out to be valid. And it's a creditor that we didn't know about, was hard to find. And the estate, if had it been closed, could have avoided paying that creditor. Now, I'm not saying we avoid paying, debts that we are responsible for paying, but there's a reason for that creditor process, right? We want to make sure that when we close the estate, the beneficiaries are confident that they're not going to have any of the deceased person's creditors going after them. And so the longer the estate is open, the more risk we have with creditors coming out. So that was a very true experience and really something that could have been avoided, had the personal representative just not delay. Okay. So another issue that I see does have to do with missed deadlines as well, but this time we're talking about missed disclaimer deadlines. So what's a disclaimer? I have, again, other resources that really go into what this is, but essentially disclaimers, let me just simply put it, anyone who is set to inherit from a deceased person, they can decide whether they want to inherit or not. And it's called disclaiming assets. So if they disclaim the inheritance, then what happens is they won't receive it. And we'll look to see, well, if this person didn't survive, who receives it next? Now, most people will say, well, if you're getting inheritance, why would you do that? We actually use disclaimer as a strategy when we are preparing estate planning documents to minimize estate taxes. It's a really great flexible strategy as long as you have someone who won't delay and will execute. But you only have a 9-month window to make this happen. And so I have had clients come to me, or persons who have become clients come to me well after that 9-month deadline because they're finally said, okay, well, I need to get started on this estate administration. They have lost all opportunity to disclaim assets. And it was a part of the decedent's estate plan to disclaim. And usually when we disclaim, we basically are moving money to another bucket, if you will. And that bucket still supports the person disclaiming the asset. It just prevents it from being taxed later on. That's all I'll say about it. But we have missed those deadlines because of delays. And I've also missed those deadlines. This isn't really a delay, but those deadlines have been missed because the person is working with an advisor who doesn't understand the planning, and the advisor goes ahead and moves all the accounts or assets into the inheriting person's, usually it's a spouse, into their own name. That disqualified the disclaimer, and all of the tax planning strategies went out the window. So that's not really a delayed issue. That's just a side note here because I see it too often with, kind of moving things with advisors instead of working with attorneys who have put these plans in place and can help execute them appropriately. The other, and I talked about this a little bit, but I have this here as one of my one of my bullet points, is delayed distribution or delayed closings. The longer you delay, when we're dealing with estates, the longer beneficiaries have to wait before they access their inheritance. It could affect their ability to buy a home or pay off a debt or maybe plan for their own estates. And again, this only triggers resentment and suspicion, and it can increase litigation costs. And it really causes an emotional strain, right? And it could provide potential hardship for heirs. So when estates are going through probate, in Oregon, we can't disperse the assets unless the court gives permission. And the court doesn't give permission to disperse assets until it's satisfied that all taxes have been paid, all debts have been paid, all creditors have been paid. And that takes some time. And if we're delaying on getting that stuff done, it's going to cause a lot of problems for the beneficiaries because they can't inherit until the court is satisfied. And that takes some time in its own right, even if we're not delaying. So closing the estate is just going to increase delays, and it's also going to delay distributions. Now, when we come to trusts, yes, we can disperse assets without court permission. However, if I am working with a trustee, we are not going to disperse most of the assets. We might disperse a little bit here and there, but we're not going to disperse all of it until we know what the liabilities are. And a lot of times we can't determine what the liabilities are until we know the value of all the assets, and we can determine what that estate tax liability will be. So delay is going to delay distribution to the beneficiaries. So some takeaways here for you is one, I know it's hard. I understand if you lose a person, and it's a lot. I tell my estate planning clients all the time when we're talking about who will be that successor trustee or who will be that personal representative to settle your estate. You want to choose someone who's organized. You want to choose someone who doesn't procrastinate. You want to choose someone who communicates. If you choose somebody who has all three of those requirements, likely there's not going to be a lot of delay. They're going to get things done. The beneficiaries won't get suspicious because there's good communication. We can hopefully open and close things well within one tax year, and the beneficiaries can get their inheritance much sooner. I know it can be hard, and I'm not saying that you have to rush when you are settling an estate, but you do have to start. Not taking action is the worst because of the tax deadlines and those penalties and interest I talked about. And I really, my other point is you really need to talk to a professional. I love it when my clients do have financial advisors they work with because they can be super helpful in this process. However, you need to work with an attorney who will work with your financial advisor. And that's because financial advisors do what they do best. They understand assets and advising about finances and so forth, but they are not lawyers, and they don't know necessarily the tax strategy behind certain things. Now, there are a lot of financial advisors who do, so I'm not saying that they don't. I have just seen all too often that not working with an attorney has caused issues later on because they received advice that wasn't in their best interest unknowingly. It's a knowing advice, and accounts get moved. We've disrupted the plan because we didn't consider this disclaimer. So please just start. Talk to an attorney. I know it costs money to talk to an attorney, but I am telling you, it is cheaper to talk with an attorney and work with an attorney early on than try to do it yourself. I have had clients who waited, and because they didn't really understand or know what they were doing. It just inherently caused delays. And when they get to me to help them, I'm going back and unwinding a lot. And that just takes more time and more costs, more fees. So please, when you think about who to put into these roles, you really want to think about the delayed piece. Procrastinator is usually not a good person to put in this role. Oftentimes we are naming for our spouses out there. We are naming a surviving spouse, and that does make a lot of sense. However, it might make sense to name your spouse and maybe another person. And the other person could be the one who helps drive getting these things done because the surviving spouse is going through grief. So there's some things that you can do in those situations. I think those are kind of some of the most hard ones, is when we have fiduciaries who have large families they have to deal with and they just get overwhelmed, because being in a fiduciary role, you are essentially working for the beneficiaries. And you have they have lots of people asking them for questions. And if you aren't taking steps to move things forward, it's only going to cause more problems. And then I have my surviving spouses that are just grieving. And I understand. I understand that. And they really are in a fog for a period of time. So if there's at least someone that the surviving spouse can lean on to help move these things forward, that is always a really good idea. So, bottom line, delays cost money. They will add strain to relationships, and it will limit your options. So the sooner that the fiduciary begins, the more control they have, and the more likely the people that you love will be protected. If you or someone you know is feeling stuck or overwhelmed by a probate or trust administration matter, please reach out to us. It doesn't matter if it's been a month or a year since someone's passed. We are glad to help move things forward, clarify, and it'll just give confidence in your trustee or executor. All right. Thanks for listening today. If you found this episode helpful, please share it with a friend. You can subscribe to the show as well. I am putting podcasts out there, hopefully twice a month. And there's a lot of tax changes and things going on in the world, so there's a lot more to talk about. Until next time, take care. And remember, you don't have to do everything, but you do have to start. If you're enjoying the podcast and finding value in the content we're providing, we would greatly appreciate it if you could take a moment and support us by leaving a 5-star review on Google. This review helps us reach more people who might benefit from the information and insights we share here on the show. Plus, it lets us know what you like and how we can continue to improve. So if you're finding our podcast helpful and informative, please take a moment to give a 5-star review on Google. It only takes a minute, but it makes a huge difference for us. And also, don't forget to leave a comment too. We love hearing from our listeners, and your feedback helps us shape future episodes. So please help us spread the word and get the conversation going. Thank you so much for your support.